This is a reading for Wayfarer's response to Lively's opposition to the motion for judgment on the pleadings. This will be no commentary, just reading, so we're going to get right into it. This is the Wayfarer defendant's reply to the opposition to motion for judgment on the pleadings. Again, I'm going to just go through the table of contents. I'm not going to read those. If you want to read it and the case law, you can come back and look at this. And here we go. 1. Introduction. Lively's opposition hinges largely on extrinsic evidence, including all arguments and evidence submitted in support of her opposition to defendant's summary judgment motion, an implicit admission that, as pleaded, her claims are deficient. Lively, however, provides no authority that might permit the wholesale incorporation of facts and argument that purportedly would have supported her claims had they only been pleaded. Lively not only fails to show how or why the court should stray from the rule that in considering a motion for judgment on the pleadings, the court is confined to allegations on the face of the pleadings, documents integral to the complaint and matters judicially noticeable, she fails to show that the new evidence she proffers would provide material support for her claims and cure the deficiencies in her pleadings. Specifically, and among other things, the new evidence Lively advances falls far short of establishing the nexus between California and defendants' allegedly wrongful conduct sufficient to overcome California's presumption against extraterritorial application of FEHA and Labor Code 1102.5. Plaintiff does not even try to substantially respond to her failure to plead an adverse employment action, a critical element of her retaliation claim, but merely refers the court to her summary judgment filings, which are similarly cited to support her defamation claims. This is a pleading motion directed to deficiencies in the complaint. By relying on extrinsic evidence first submitted in connection with the summary judgment motion, Lively concedes that her complaint, standing alone, is insufficient to plead her claims. Succinctly put, deficiencies in a complaint cannot be retroactively cured by evidence submitted in a summary judgment opposition or merely proffered in opposition to a Rule 12c motion. 2. Plaintiff's opposition relies on facts and evidence extrinsic to the complaint. A motion for judgment on the pleadings tests the sufficiency of a pleading. When deciding a motion on the pleadings, the court must confine its consideration to the pleadings and their attachments to documents incorporated in the complaint by reference and to matters of which judicial notice may be taken. Implicitly conceding that, as pleaded, her claims cannot withstand a motion to dismiss, plaintiff offers several options for the court to consider. Extrinsic facts, including 1. The wholesale incorporation of arguments and evidence submitted in connection with her motion judgment opposition. 2. Conversion of defendant's motion for judgment on the pleadings to a motion for summary judgment. And or 3. An amendment to conform the complaint to proof. The court should decline plaintiff's invitation to depart from the rules applicable to motion to dismiss. Plaintiff first fails to cite authority for the notion that all arguments and facts set forth in her summary judgment opposition can be incorporated into her opposition to a Rule 12c motion to dismiss. To the contrary, a party may not incorporate by reference an argument in a summary judgment motion into a motion for judgment on the pleadings. Plaintiff punts to Rule 15b-2, which provides that when an issue not raised by the pleadings is tried by parties, express or implied consent, it must be treated in all respects as if raised in the pleadings. The rule further provides that a party may move at any time, even after judgment, to amend the pleadings to conform them to the evidence and to raise an unpleaded issue. Thus, although it is often said that one may not amend one's complaint via an opposition to a motion to a summary judgment motion, Rule 15b-2 provides that issues not raised in the pleadings are treated in all respects as if raised in pleadings if they have been tried by the parties' express or implied consent. Accordingly, 15b amendments to conform to proof have been permitted to add new claims or legal theories in the context of a summary judgment motion where a fact or evidence has been placed at issue and thus raised with the party's consent. Rule 15b does not apply to this motion for judgment on the pleadings. Defendants did not raise Lively's new evidence or indeed any evidence in its Rule 12c motion, which focuses solely on the legal deficiencies in the complaint. And, of course, the facts have not been tried at trial or at an evidentiary hearing. Thus, defendants have not consented to try the new facts or evidence proffered by Lively. Finally, defendants did not raise the issue of extraterritoriality in their summary judgment motion and therefore did not try the issue by consent, even assuming consent to the admission of extrinsic evidence on a motion to dismiss can be created by presenting evidence in support of a summary judgment motion. Defendants do not dispute that Rule 15b allows a party to move at any time, even after judgment, to amend the pleadings to conform the evidence. Plaintiff has not moved to amend her pleadings, even though defendant's motion was filed on September 26, 2025, giving plaintiff ample time to seek a proper amendment, affording defendants the opportunity to oppose an amendment to add new facts. Notably, where a complaint is dismissed without leave to amend for failure to state a claim, evidence that might support a claim on summary judgment is rendered irrelevant and, in fact, will never be presented as the matter will not proceed to the summary judgment stage. As noted, Lively offers no authority for the notion that a summary judgment motion can retroactively amend a complaint to salvage claims that were not sufficiently stated in the first place. Nor can defendant's Rule 12c motion be converted to a summary judgment motion. If, on a motion under Rule 12b-6 or 12c, matters outside the pleadings are presented to and not excluded by the court, the motion must be treated as one for summary judgment under Rule 56, and all parties must be given a reasonable opportunity to present all material that is pertinent to the motion. Plaintiffs suggest that because defendants presented evidence relating to an adverse employment action in their summary judgment motion, the court should not convert the motion for judgment on the pleadings. Conversion, however, is appropriate when a moving party bases its motion to dismiss on extrinsic evidence. Defendants have not cited any extrinsic evidence to support of its motion for judgment on the pleadings, and plaintiff does not cite any decision in which a court has converted a motion to dismiss to a summary judgment motion because plaintiff opposed with extrinsic evidence. Any such rule would obliterate the distinction between motions to dismiss for failure to state a claim and summary judgment. 3. Plaintiff concedes that the complaint fails to allege an adverse employment action under FEHA or Title VII. Plaintiff does not even bother to address her failure to plead an adverse employment action as required under retaliation under FEHA or Title VII. Plaintiff only glancingly refers to an adverse employment action in her introduction, stating in the most conclusory fashion that she more than adequately pled an adverse employment action and casual links. Failure to oppose an issue raised in a motion to dismiss effectively concedes the issue. Plaintiff merely directs the court to the arguments and evidence submitted in her summary judgment opposition. As explained above, a party cannot effectively oppose a legal argument framed in defendant's motion to dismiss by simply incorporating by reference an argument asserted in her opposition to the defendant's summary judgment motion, and doing so cannot retroactively cure a failure to state a claim in the first place. In fact, the only plausible explanation for this critical omission is that plaintiff seeks to evade the court's 25-page limit for her opposition. Incorporation by reference is not a proper device to avoid the page limits. Since plaintiff concedes that she failed to plead an adverse employment action, her retaliation claims under FEHA and Title VII should be dismissed. 4. Plaintiff fails to overcome California's presumption against extraterritoriality. In a particularly muddled argument, plaintiff argues that a choice of law provision in plaintiff's unexecuted loan-out agreement abrogates California's firmly established presumption against the extraterritorial application FEHA. Implicitly acknowledging the frailty of this argument, plaintiff falls back on facts extrinsic to the complaint to establish a nexus between California and the material elements of her FEHA discrimination and retaliation claims. These arguments not only fly in the face of firmly established California law, but contradict plaintiff's own pleadings. To salvage her claims under FEHA, plaintiff engages in a tortured choice of law analysis to argue that California's presumption against extraterritoriality does not apply even though Lively is not a California resident, and her own pleadings establishes that the allegedly offending conduct occurred outside California in New York and on the New Jersey set of It Ends With Us, the film. Lively suggests that a choice of law provision in Lively's unexecuted Actors Loan Out Agreement, the ALA, somehow supplants the rule governing extraterritoriality and that FEHA does not include a geographical limitation. The parties cannot contract around the extraterritoriality constraints of California statutes, even if they wanted to. A contractual choice of law provision cannot determine whether a given statute is to be given extraterritorial effect because that question requires a court to focus on legislative intent rather than on a party's intentions as expressed in a contract. It is well settled that extraterritoriality is a matter of statutory construction, and parties cannot create by contract a cause of action that California law does not provide. And then they cite case law rejecting plaintiff's argument that the choice of law provision in her employment contract provides the protection of California's substantive labor laws upon finding that because the California wage and hours law contain limitations that they do not apply extraterritorially, parties cannot by contract extend their reach. Contrary to Lively's allegation, FEHA contains clear geographical limitations. The California's legislators' finding and declarations of policy provide that FEHA protect the public welfare, prosperity, health, and peace of the people of the state of California. In 1984, the legislature reiterated its intent to restrict FEHA's scope. The legislature finds and declares that it is the existing policy of the state of California to prohibit harassment and discrimination in employment on the basis of any protected classification. Such conduct, whether intentional or unintentional, is a violation of the civil rights of California citizenry. More case law. FEHA itself states, this part shall be deemed an exercise of the police power of the state for the protection of the welfare, health, and peace of the people of this state. When a law contains geographical limitations on its application, courts will not apply it parties failing outside those limitations, even if the parties stipulate that the law should apply. Thus, as the California Supreme Court explained over a century ago, basing the geographic reach of California statutes on the circumstances of a private contract is not tenable, and extraterritoriality resolves itself then into one of the correct interpretations of our statute. Choice of law provisions come into play only if the legislator has determined the statute can apply in a given context. In other words, they reflect the party's choice among the collection of laws that could apply. They do not add new and different laws to that basket of options. Moreover, a contractual choice of law provision that incorporates California law presumably incorporates all of California law, including California's presumption against extraterritorial application of its law. And because of California's choice of law provision embeds California's presumption against extraterritoriality and consequent implicit geographical limitation, it cannot be used to circumvent these very principles. In short, the ALA's choice of law provision does not abrogate the well-established principle that the presumption against extraterritoriality applies to FEHA. To overcome the presumption, Lively must plead a specific factual nexus between the defendant's California activities and the majority of allegedly discriminatory conduct. cases in which a factual nexus was found are not comparable. For instance, in Doe versus Maxim, the court found a factual nexus where the complaint alleged the plaintiff met with and was hired for an offshore photo shoot by a California defendant who knew, based on the photographer's histories, that the photo shoot was an opportunity for SA. Lively admittedly did not plead the required nexus and instead urges the court to consider new facts that purportedly create the necessary link, and the new facts proffered by Lively are insufficient to establish the requisite factual nexus. Lively points to a pre-production statement by Jamie Heath, presumably in California, hoping for a successful birthing of the film project. It strains credulity to argue that using the term birthing as a substitute for creating was sexual or harassing in any nature. More importantly, there is no allegation or evidence that Heath or any Wayfarer party knew or had reason to anticipate discriminatory conduct. In this vein, Lively notes pre-production communications relating an HR department and Wayfarer's decision not to have a full-blown HR department for the film. According to Lively, such decisions purportedly made in California set the tone for harassment. Whatever that means, a decision on the scope of HR services without any link to a motive to promote harassment or somehow avoid future liability for harassment is not sufficient to plead a casual link between California and discriminatory conduct which allegedly occurred on the film's film in the spring of 2023. Lively also points to complaints by Lively to Sony about conduct on the set. Sony was not Lively's employer. Sony is not affiliated with Wayfarer and, as Sony told Lively, was not a proper party to receive her complaints. Sony referred Lively to the Wayfarer principals in New York. Even assuming the court were to consider this extrinsic facts, they are insufficient to plead a nexus between the allegedly wrongful conduct on the film set in California. As for Lively's retaliation claim, Lively contends it was created and launched by crisis manager Melissa Nathan, public relations representative Jen Abel, and Jed Wallace. While Nathan and Abel may have been in California, they are not Wayfarer employees, were not involved in the allegedly wrongful conduct, and cannot be liable for retaliation wherever it occurred. 5. Lively fails to show that her defamation claims are adequately pleaded. Lively again relies primarily on extrinsic evidence presented in her summary judgment opposition to refute defendants' arguments on the deficiency of her defamation claims. First, relying solely on citations in her summary judgment opposition, Lively contends that defendants' opinion defense is meritless. However, the only defamatory statements identified by Lively are Mr. Friedman's statements to the press on his opinion on the merits of Lively's claims and conduct in the litigation. Lively argues that New York and California's litigation privileges do not apply to statements to the press. Lively cites Rothman versus Jackson for the proposition that California's litigation privilege does not apply to litigating in the press. There, the lawyer defendant accused another lawyer of making public statements to extort a settlement from Michael Jackson. Mr. Friedman's statements, in contrast, were made after Lively filed her complaint in December 2024 and expressed his opinion on the merits of her claims. Unlike the lawyer in Rothman, Mr. Friedman is not a defendant, and plaintiff fails to show why his public statements are a proper basis for a defamation claim against the defendants. Lively next argues that New York's fair report privilege does not apply because the defamatory statements constitute litigating in the press and do not reflect reports of any judicial proceedings. Lively again turns to her opposition to defendant's summary judgment motion, pointing to statements which she alleges were not made to report on judicial proceedings. However, the statements by counsel, to the extent they can even be construed as defamatory, which they were not, merely repeat defendants' assertions made in court and fall within the scope of protected speech under Section 74. 6. Lively's joint employer argument is misplaced. Lively devotes 2 pages to an argument that defendants did not make, namely, that Wayfarer should not be dismissed because, although Wayfarer was a joint employer with It Ends With Us movie, liable under FEHA and Title VII. In a footnote, defendants merely note that Lively blurs the lines between Wayfarer and It Ends With Us movie, Lively's employer. And we have case law. Even if defendants made this mythical argument, Lively's joint employer theory was not adequately pled, as there are no allegations that Wayfarer paid Lively's salary, hired her, or had any control over her daily employment activities. Common ownership, supplying administrative support, and shared HR policies fall short of the level of control the joint employer doctrine demands. Conclusion. For the foregoing reasons, and those set forth in defendant's motion for judgment on the pleadings, defendants respectfully request that the court enter an order granting this motion and dismissing plaintiff's claims with prejudice. And this was signed by Ms. Ellen Garofalo on December 12th, 2025. Thank you. And if you enjoyed this reading, please make sure to like and subscribe and even leave a comment. It really helps with the algorithm. Thank you.